Hello, everybody. Welcome to the Constitutions and Statutes video. This video lecture is part of the English legal writing course. What will we learn today in this video? So we are talking about constitutions and statutes. So we'll compare the different stages in a statute's life cycle. Look at the properties of a code, how it's organized, the annotations. Then we'll dive into aids to find specific statutes and dive into Westlaw and look at kind of some how Westlaw treats statutes. So in another video, you have learned that the Constitution is the highest source of law in the United States legal system. So there is, since it's the highest form of law, no other law can be validated if it conflicts with a constitutional provision. Statutes, on the other hand, constitutionally valid statutes, are the second highest source of law in the United States. So a statute will usually control a given legal problem over case-made legal rules. This has been the tradition in the Anglo-American legal tradition. So the life cycle of a statute. So statutes come from, where do they come from? They come from legislatures. So when a legislator wants to create a new statute, she introduces a bill in whichever house she belongs to. And after the bill is introduced, the bill will get a number, beginning with the house of origin. So, for example, if we're on the federal level and it's introduced by the House of Representatives, then it'll begin with the letters H.R. If it's introduced by the Senate, then it'll begin with the letter S. States will do the same thing. The bill numberings usually, they'll correspond with the legislative session. So as a researcher, we'll need to be aware of which session which session of a legislature considered the bill. We'll usually kind of look up the legislative history if we're trying to figure out the legislative intent. So that'll be this will be important information if you're trying to determine kind of the intent, the background of a law or the bill. So when the bill gets passed by both houses of the legislature, it's signed by the executive, or it can also be vetoed by the executive. But barring a veto, it becomes a statute. You can call this a statute, an act, or a law, are common terms. But at the federal level, passed bills become known as public laws, with a capital P and a capital L. So these public laws will receive a unique number, beginning with the number of the congressional session in which the law was passed. The GPO, the government publishing office, will publish each public law as what's called a pamphlet or a slip law. Slip laws are quick, and due to their quick publication, they give the public proper notice of this new law. The slip laws only contain one statute in isolation, so they're but they're less useful in terms of research purposes. So at the conclusion of the legislative session, the printer will gather all the statutes passed and publish them in as part of a multi-volume set known as the session laws. These are the statutes at large act as the session laws in the federal level. Different states call their session laws different things. So after this initial publication, that's when the statutes go through codification. So what is codification? It's the arranging, systematizing the laws in a given jurisdiction in an orderly fashion, in a fashion where we can browse, we can search, and we can know where to look for the laws. The federal government will title its codes in the United States Code, the USC, and for each title, we'll have each a different name. So then, using the code. So in general, as lawyers, we use or will conduct the bulk of our research using the codified versions of the statutes. And when we cite, we'll cite to the codified version. And this is valuable because of their topical organization, right? They all have, they'll have a number, a volume number, and a title. So once you find a code provision on point, then you can check the nearby provisions to see if anything is helpful for you or your research, right? You know you're in the same area of the code. So we start with title, but the most basic piece of the code is what's called a section. And this provides for a specific legal rule in a particular circumstance. Codes then group the sections into chapters. We might have subchapters as well, but basically it goes from a section to a chapter. And then from the chapter, go together into the title. And this is, it's the largest unit of organization in the federal code. Other than arguably the code itself, but it's the largest organization. So you'll see something like Title 18, Title 22, that sort of thing, with its own table of contents. Now, sometimes there will be a publication of the code by itself, but sometimes the code will have a annotated version. So they might designate a private entity like Lexis or West, to provide an annotation. Excuse me. And here you'll see instead of USC as the citations, West publishes the USCA, meaning United States Code Annotated. Lexis provides the United States Code Service, USCS. So they're reprints of the USC, but with annotations. So when they sell these annotations, as part of their service to make money. So, and these are valuable for your research because, you can search and find code and find some annotations. Annotations meaning kind of explanations about the authority. And through the annotation or the code, or through the annotation, you might find the code that's necessary, and through the code, you might find a valuable annotation that's valuable for your research. So let's look at let's just jump in into Westlaw to see what we're talking about here. So in Westlaw, you'll see again regulations here, secondary sources, statutes, and court rules. So here we have the statutes and the USCA. Remember, we're in Westlaw, so this is West. So West's version of the USC annotated version is the USCA. So let's just click into that and see what we have. So we can see the different titles. Of the USC. So if we go into, let's talk commerce and trade. Since in these videos we've been kind of using the theme of unmanned aerial vehicles, the export of unmanned aerial vehicles, Title 15 is one of the important titles. So you'll see now the different chapters, right? So the different chapters under the title, and it's pretty comprehensive, the number of chapters, and then the sections, the subsections here we talked about. So sections are merged into chapters, which are merged into titles. So if we just click into one, definitions, then we see the definitions here. So let's look for one that has maybe a annotation. So we'll want to eliminate that pause, of course, and start with the following. So you'll be able to browse the United States Code annotated section as well, and states as well. So if we look at Indiana, we can see the Indiana statutes and court rules as well. So again, if we use our search terms up here, and we'll continue with our theme of unmanned aerial vehicles and export. We'll see what we have. So again, we have our first page here, and along the side, we'll have statutes and court rules. And if we click in there, you'll see the sections that relate to the export of unmanned aerial vehicles. And if we look at Title 22, the export of arms, this is the what you might find you've heard of as ITAR, but this is the statutory provision. This will relate to unmanned aerial vehicles. And let's just find where it is. Here we go. Here's where we see unmanned aerial vehicles. And you'll see all the other sections that relate to that as well. All the different sections of the code. So that was a little introduction to Westlaw. So in terms of interpretation and the interpreting constitutions and statutes, we know that constitutions and statutes tend to be broadly written in order to apply to a broad range of facts. And they lack specifics. So what happens is that there be regulations that get more specific and will drill down to the specifics of a certain statute. Lawyers will also look to judicial opinions that interpret a statute to inform us how we will interpret a specific statute. But sometimes you might come across a situation where a statute hasn't been interpreted by a court. So what do we do? What we will try to do is you might argue for some interpretation based on the intent of the body that created the authority, right? And the body meaning, what was it, the House, Senate, or was it in a state? And so this is kind of an intent-based argument. So we talk about, and to make these intent-based arguments, one way is to look at the history of the authority's creation. So with regard to constitutional history and what's called the framers' intent, we look to the people who drafted the Constitution, or the framers of the Constitution. Most lawyers don't really, you'll rarely find yourself needing to do this. because most constitutional provisions have been sufficiently litigated, and there are cases interpreting them. But you may need to look into the drafters to do this intent-based research. So, in addition to the Constitution itself, so this when the Constitution was written, there were other little bits of work product that were compiled by historians. You can find this in the records of the Federal Convention of 1789. There were also in the Federalist Papers. These are a series of essays arguing for ratification of the Constitution. So those essays are called just the Federalist Papers. There is also a body of work called The Debates in the Several State Conventions on the Adoption of the Federal Constitution. A historian gathered the documentation from the various ratification debates that took place in the different states. States might have similar documents in their historical records as well. So in terms of statute history, we also have this idea of legislative history and legislative intent. And both of these, so in terms of legislative history, this refers to the conversations leading up to the enactment of a statute. Right, so there will be hearings, committee reports, floor debates, etc., and all of these things go into the record, into its legislative history. And as lawyers, we can use that history in various ways for our research and for making arguments. Basically, one way saying, okay, a particular legislative intent indicated that the interpretation of a certain statute should be thus. So what are these type of legislative history documents? So you'll see that there are conference committee reports, and these are reports of the committee which will talk about the differences between the bills passed by each house. There's committee reports. These are the official reports of whatever committee reviewed the bill. We have the Congressional Record. This is the official journal of the legislature. And this record might contain debates relating to a bill. Sometimes there will be hearings. So these are basically transcripts of hearings held by legislative committees. You'll also see what's called committee prints. Sometimes there are reports commissioned by legislative committees to study a bill. And another kind of legislative history document would be the signing statement. The statement issued by the executive when signing the bill into law. All I'd like to talk about in this video. Thanks, everybody, and take care.